Another big victory in the Second Amendment community thanks to the New York State Rifle and Pistol Association versus BRUEN decision. And this is another kick in the teeth for California and their anti-gun scheme of telling the people there what guns they can buy because of a roster. And they're not the only state that has this, but this is a huge lawsuit. Let's talk about it. First, I want to thank the sponsor of the video, and that's Bullet Safe. Guys and gals, Bullet Safe's VP3 vest is super affordable, coming in at under $300. It's super comfortable, full range of motion. It's NIJ level 3A certified, which means up to a 44 Magnum. It's extremely light, starting at 3.9 pounds. It has pockets for expansion if you want to throw in rifle plate, and they've moved manufacture to the United States. Guys and gals, check them out down below, and if you use code GADGET10 at the link in the description and the pinned comment, you'll save 10% on your order. I have one of these. I actually use it. Depending on what I'm doing and where I'm going, I actually use this vest. It can conceal under t-shirts. It is extremely comfortable. Check them out, Bullet Safe, down below. And don't forget to use that coupon. Thanks to Bullet Safe for being a friend of the channel. All right, guys and gals, let's talk about what happened in California. This actually came out in the late evening here in Massachusetts yesterday, but it's a case in California, so it was right around the close of business. And this judge kicked California's teeth in with the handgun roster. Now, this is the second preliminary injunction that's been issued in 2 weeks on the California Safe Handgun Act roster. And if you haven't watched the first video, I'll float it above here if you're watching on YouTube. But California has three main things on their roster. The first one is a loaded chamber indicator. And what it is, it's a little, but just what it says. It's something on the gun that tells an idiot that, oh, you have a bullet in the chamber, idiot. And then there's a magazine disconnect. So if you drop the magazine, the gun will not fire. And the third is microstamping. Every time the gun were to fire a round, it had to imprint a specific code, numerals and letters that was specific to that gun on every round it fired for tracking and tracing. And that technology doesn't exist. So, as a result, no new guns have been added to the California Safe Handgun roster in years, a decade. So that means, as you know, the plaintiffs in this case, they wanted to buy guns like the Gen 4 or Gen 5 Glocks, Smith & Wesson EZs, P365s from SIG, all the new guns that are inherently safer than older generations, but California says that you can only buy unsafe guns unless a gun has those three things all in one. It's a scheme to stop the amount of firearms being sold in the state, thus being available to the public. It's a violation of the Second Amendment. We all know it. In fact, I was just working with some attorneys from Firearms Policy Coalition about that same thing in this state. And this victory was brought to us by Second Amendment Foundation and Firearms Policy Coalition. This is the case. It's Rena v. Bonta. And we'll start out with the injunction here. It says plaintiffs seek to enjoin enforcement of California's handgun roster requirements, which have prohibited the manufacture and retail sale in California of a large segment of modern handguns that are otherwise in common use throughout the United States for self-defense and other lawful purposes. The challenged roster requirements are codified in California's Unsafe Handgun Act and limit handgun manufacturing and retail sales to those handguns that can satisfy numerous testing and safety features requirements not required in 47 other states. As a result, plaintiffs allege no modern handguns have been added to the roster's list and approved for commercial sale in more than a decade, and the limited number of handguns currently listed on the roster continues to shrink because of the testing and safety feature requirements, as well as the assessment of annual roster fees on manufacturers as a condition to retention of their handguns on the roster. Plaintiffs further allege the roster will shrink at an accelerated pace in the future because the Unsafe Handgun Act's 3-for-1 roster removal provision, which mandates for each new roster-compliant handgun added to the roster, 3 grandfathered handguns must be removed in reverse order of their dates of admission to the roster. Plaintiffs argue these roster requirements all operate together to ban the retail sale of hundreds of modern off-roster handguns in common use and violate their rights to keep and bear arms secured by the Second Amendment to the United States Constitution. Despite plaintiffs' requests to enjoin the entirety of the UHA's roster requirements, their focus has been on 3 specific requirements of the UHA and the impact of those requirements on a particular type of handgun, semi-automatic pistols. These types of handguns have been banned from commercial sale in California because they lack 3 features required by the UHA. 2 of the mandated features require that these arms have a chamber load indicator and magazine disconnect mechanism, both of which are designed to prevent accidental discharges and increase gun safety. The 3rd requirement, microstamping, is intended to help law enforcement solve gun-related crimes by allowing quick identification of the handgun used at a crime scene from information imprinted on the spent cartridge casings. Defendants argue the California legislature passed these requirements to further important state interests, gun safety, and general public safety through enhanced criminal investigations. While the topic of gun regulation and its permissible scope is hotly debated in America's political theater, the role of this court is to determine whether the roster provisions of the UHA violate plaintiffs' Second Amendment rights under United States Supreme Court precedent in New York State Rifle and Pistol Association versus BRUEN. BRUEN abrogated the means and approach used by circuit courts across the country to determine the constitutionality of gun regulations under the Second Amendment, including a Ninth Circuit decision that previously upheld the UHA's chamber load indicator, magazine disconnect mechanism, and microstamping requirements. Under BRUEN, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct, in which case the state may not simply posit that the regulation promotes an important interest, such as public safety. Rather, to justify its regulation, the state must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulations. Under this newly formulated standard, the court concludes that plaintiffs' desire to commercially purchase newer models of semi-automatic handguns in common use is covered by the Second Amendment and presumptively protected. Because the state is unable to show the UHA's chamber load indicator, magazine disconnect mechanism, and microstamping requirements are consistent with the nation's historical arms regulations, plaintiffs are entitled to a preliminary injunction against the state's enforcement of those 3 provisions, which operate to prohibit the commercial sale of these arms, as well as the 3-for-1 roster removal provision, which depends on the enforceability of those provisions. However, plaintiffs have not met their burden to show that the UHA's roster listing requirement and its fees, safety device, and testing requirements violate their Second Amendment rights. Plaintiffs' motion for preliminary injunction is therefore granted in part and denied in part. So the judge is saying, look, California, you can't enforce the loaded chamber indicator, the magazine disconnect, and microstamping. Can't do it. Can't even do the 3-for-1 removal. Not going to have it. It's a violation of the Second Amendment. And thus, a preliminary injunction was granted. Now, part of this, the previous case too, is law enforcement in California. All of them are using unsafe handguns according to California's roster. And that when law enforcement actually jumped in support of getting rid of this roster, it kind of opened up some eyes, and the anti-gunners didn't like that. Not one bit. But then there's this, the stay pending appeal. Under Federal Rule of Civil Procedure 62 Charlie, the district court has discretion to stay enforcement of an injunction pending appeal, similar to what Judge Roger T. Benitez did with Freedom Week, right? With magazines. The defendants ask the court to stay enforcement pending appeal. A stay is not a matter of right and depends on the circumstances of the particular case. Courts consider 1, whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent the stay. 3, whether issuance of the stay will substantially injure the other parties in the proceeding. And 4, where the public interest lies. The first 2 factors are most critical in determining whether a stay is appropriate. While plaintiffs have demonstrated likely success on the merits, the defendants will not be irreparably injured absent a stay. The court believes an orderly process is in the best interest of the parties. The UHA has prohibited commercial sales of the handguns at issue for more than a decade. The lawsuit has been pending since November 10th of 2020, and the parties have litigated at a leisurely pace since its inception. Everyone was waiting for BRUEN. Its arrival does not erase the prior pace of this litigation and need not hasten it now. Moreover, the district court in Boland, which was the case 2 weeks ago, recently enjoined enforcement of the chamber load indicator and the magazine disconnect mechanism and microstamping provisions. There, the court stayed enforcement of the injunction for 14 days pending the state's decision whether to file an appeal. The state has since filed an emergency motion for partial stay pending appeal of the preliminary injunction issued in Bolin. On March 22 of 2023, after a decision in Bolin was filed, this court held a status conference with the parties. Both parties requested that the court issue its decision as this case was filed first and presents issues not addressed in Bolin. Therefore, the court issues its decision herein, but stays enforcement pending appeal or further hearing on this matter. Then we'll go to the conclusion and the order. For these reasons, the court hereby orders the following. 1. Plaintiff's motion for a preliminary injunction is granted as to the California Penal Code blah 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 in reference to the chamber load indicator, the magazine disconnect mechanism, microstamping, and the 3-for-1 removal provisions. 2. Plaintiff's motion for a preliminary injunction is denied as to the other alleged provisions of the UHA. That's the fees and stuff that California puts on manufacturers, etc. 3. The defendants are enjoined from enforcing California Penal Code, blah, 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 again, for the CLI, MDM, microstamping, and the 3-for-1 provisions. And 4, posting of bond is waived. And 5, the preliminary injunction is stayed pending appeal for further hearing on this matter, whichever comes first. The court sets the matter for a telephonic status conference on April 14th of 23 at 1:30 p.m., at which time the parties shall advise the court how they wish to proceed. It is so ordered, March 31, 2023, and this is Judge Dana Sabra, who's the Chief Judge, U.S. District Court in the Southern District of California, which is in the Ninth Circuit. So, good news. The second case in as many weeks has said California's restrictions on firearms for those safety mechanisms is unconstitutional. So the light is at the end of the tunnel, folks in California, folks in Massachusetts. Let's stay focused. Let's support those who support us. And it won't be long before this case comes to a close. So we'll be waiting as this proceeds. If you're interested in the Second Amendment, guys and gals, you're interested in this, if you live in California or Massachusetts, you have a handgun roster, or you just think that this is a blatant violation of the Second Amendment and it needs to go away, then like the video, share the video, and subscribe to Guns and Gadgets. This is where you get the Second Amendment news every single day. And thanks to you for allowing me to do it, because I won't do it without you. Guys and gals, until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I'll see you all on the next one. Take care.